He laughed at her evidence. She pulled out a folder and exposed 12 cases of judicial bias on live record. In 30 minutes, a 33-year-old Congresswoman unraveled a federal judge's career in front of the nation. Was this justice or the beginning of a reckoning the courts never saw coming? Before we get to this explosive moment, tell us where you're watching from, and if you believe truth still matters, hit subscribe. We've got another jaw-dropping story coming tomorrow. The courtroom was full, reporters in the back, attorneys flanking both sides, clerks typing, cameras clicking softly. And at the center of it all, Judge Andrew H. Stones towered above the room from his elevated bench, his black robe draped neatly over the arms of his chair, his silver hair immaculately combed, his face carved into a smirk that didn't hide his condescension. He leaned back, eyes narrowed. "Let's move on to your next political point, Congresswoman," he said, his tone amused, almost bored. Jasmine Crockett didn't flinch. She didn't shift her weight. She didn't blink. She simply reached down, opened a thick maroon folder, and let the silence stretch. "Actually, Your Honor," she said with measured calm, "before we proceed, I believe the court needs to examine your own record." The room froze. A few gasps. Reporters straightened in their seats. Judge Stones's smirk faltered. Crockett raised a single sheet of paper. "I've documented 12 civil rights cases where you dismissed plaintiffs using language that appellate courts later deemed inappropriate, biased, or inconsistent with judicial ethics." She placed the paper on the plaintiff's table, then another, and another. "You've created a pattern, Your Honor, one that undermines the credibility of this proceeding." Stone's gavel hovered, his lips parted slightly, but no words came. Crockett's voice didn't rise, it didn't shake, it sliced. "I move that you recuse yourself from this case, and that your conduct be formally reviewed by the Judicial Conduct and Disability Committee." The gallery was silent, cameras captured every heartbeat. The moment stretched like a tightrope, then snapped. The balance of power in that courtroom had shifted, and no one watching would ever forget what they saw. Judge Andrew H. Stones had spent over 2 decades presiding from the federal bench, and in all that time his authority had rarely been questioned. At 67 years old, he carried the weight of tradition on his shoulders like a badge of honor. A graduate of Harvard Law School, Stones had clerked for a Supreme Court justice before being appointed to the federal bench by a Republican president. His credentials were impeccable. His reputation, ironclad. To his allies, he was the embodiment of judicial discipline, decisive, no nonsense, immune to political noise. But to those who appeared before him in civil rights cases, he was something else entirely, a relic of an era unwilling to reckon with change. They called him the Gavel King for a reason. Stones ruled his courtroom like it was a private kingdom. His gavel didn't just signal order, it ended arguments, silenced attorneys mid-sentence, and shut down anything he deemed political grandstanding. His legal opinions were littered with thinly veiled contempt for civil rights attorneys, especially those who brought voting rights, racial discrimination, or police misconduct cases before him. But when it came to corporate litigation, Stones showed a different side. He was deferential to white show law firms, receptive to complex financial defenses, and famously lenient on procedural delays. Corporations walked away from his courtroom feeling heard. Civil rights plaintiffs walked away feeling erased. Over the years, Stones had built a reputation for tossing out what he described as performative lawsuits, cases he believed were designed to score media points rather than achieve legal results. He'd said so from the bench more than once, sometimes directly to attorneys, other times through scathing written opinions that bordered on personal attacks. His supporters called it candor. His critics called it bias wrapped in bravado. But what Stones never anticipated, what decades of unchecked power had blinded him to, was that one day, someone would walk into his courtroom who didn't just challenge his authority, but dismantled it with precision. And that someone was coming with the law on her side. Jasmine Crockett was never supposed to be in this courtroom, not by the expectations of power, not by the assumptions of tradition, and certainly not by Judge Stone's design. At just 33 years old, Crockett stood as the embodiment of everything the old guard in the judiciary underestimated: young, black, unapologetically progressive, and prepared beyond belief. Raised in the working-class neighborhoods of St. Louis, Jasmine knew what it meant to be overlooked. Her childhood wasn't marked by privilege or political connections. It was built on grit, ambition, and a quiet determination to fight for those who couldn't fight for themselves. After putting herself through college and earning her law degree in Texas, she took a path that didn't lead to big law or corporate boardrooms. Instead, she went where the need was greatest, defending the voiceless in court. As a public defender and civil rights attorney, Crockett spent years navigating courtrooms that looked exactly like Judge Stone's, where formality masked indifference, and where justice too often bent away from those without influence. She knew how federal procedure worked because she had used it to keep clients out of jail, to fight voter suppression, to challenge power in its own language. By the time she won her seat in Congress, Jasmine wasn't just another politician. She was a lawyer's lawyer, someone who had lived the inequality she now legislated against. And unlike many who walked into Judge Stone's courtroom, she didn't come to perform. She came to prosecute, with data and documentation that would turn the courtroom into a crucible. She had studied Stone's past rulings. She knew the pattern, the dismissals, the reversals, the reprimands. And she didn't come to suggest bias. She came to prove it. What Judge Stone saw as just another hearing, Jasmine Crockett saw as a reckoning. She brought with her a thick folder filled with names, case numbers, appellate rulings, and procedural violations. But more importantly, she brought the moral weight of every client she had ever stood beside, and she was about to place that weight squarely on the shoulders of the man who had ruled without consequence for 2 decades. This wasn't just another civil rights case. This was a confrontation between unaccountable power and the one voice that had dared to hold it accountable. And that voice was ready. The courtroom was packed, the air stiff with expectation. Reporters lined the back wall, their pens already poised while law clerks whispered predictions to one another. Judge Andrew H. Stones, perched high behind his mahogany bench, wore his black robe like armor. To his left, a bust of Justice Brandeis. To his right, an American flag. Behind him, portraits of white male legal titans glared down. Congresswoman Jasmine Crockett stood before the court, methodical and composed. She adjusted the microphone slightly, her voice clear and unwavering. "Your Honor," she began, "this case concerns documented constitutional violations affecting over 50,000 registered voters in the state of Texas. Today, we're presenting direct video evidence from polling sites, corroborated by sworn affidavits and supported by statistical data from independent election monitors." She held up a stack of files, thick and worn. On top, a signed affidavit from a 78-year-old black voter turned away from her precinct after 50 years of voting in the same location. But Judge Stones didn't look at the documents. He leaned back and smiled. "Objection sustained," he said casually, gesturing toward the defense counsel before Crockett could even finish introducing the first exhibit. "Move on, Congresswoman Crockett." The mispronunciation wasn't subtle. It wasn't the first time either. Crockett blinked once, her eyes narrowing, but her tone remained even. "With respect, Your Honor, I'd like to correct—" "Objection," the defense interrupted. "System," Stones said without pause. "Let's not get sidetracked with formalities." The courtroom murmured. The stenographer hesitated before typing. The disrespect was unmistakable. Crockett resumed, clicking her remote to begin a presentation of side-by-side footage from 3 polling locations. Each showed eligible voters denied access, clerks citing new restrictions not disclosed, prior to the election. "Objection," came the call from defense. "Speculative, lacks foundation." "Abstain," Stone said again. "Congresswoman, if you can't bring real evidence, we'll have to move on." Jasmine remained still. "Your Honor, this is real evidence." "Move on, or I will hold you in contempt." Courtroom eyes darted between the bench and the plaintiff's table. No one moved. Stones was on a warpath, and Crockett had just drawn the first line. Jasmine Crockett took a steady breath and pressed play. On the screen, footage rolled silently. A black man in his 60s denied access at a polling station in Houston. The poll worker shook her head. No explanation, no alternate solution, just a shrug, and the door closing behind him. "This is grandstanding, not evidence," Judge Stones scoffed, waving a hand toward the screen. The courtroom stiffened. Reporters paused mid-keystroke. Even the defense attorney looked momentarily uncomfortable, eyes flicking toward the jury box. Crockett didn't blink. "Your Honor, what you're watching is the Constitution on film. That man was registered, eligible, and turned away. That is a violation of federal voting rights law." "I said move on," Stones snapped, louder this time. "Maybe stick to politics, Congresswoman. Courtrooms require more than camera tricks and headlines." Laughter, low and dismissive, the kind of laugh that stings deeper than a shout. But Crockett didn't flinch. She lowered her hands onto the plaintiff's table and spoke into the silence. "This is not theater. These are real people. This is their right, not a gimmick." Stones leaned forward. "You've made your point, weak as it is." "Then let's test it, Your Honor." The room shifted. It was subtle. The way observers leaned in, the defense lawyer swallowed, the court reporter straightened her spine. Something had changed. Jasmine continued, pulling up another clip. A woman in a wheelchair turned away because her ID didn't match the new requirements. Requirements passed just days before the election. Stones interrupted. "Congresswoman, we are not here to relitigate public opinion. If you cannot present actual legal merit, I will rule accordingly." Crockett looked up. "Legal merit? That's rich coming from a judge who dismissed the Morrison case without even reading the plaintiff's final filing." Stones froze. It was the first crack in his composure. "Excuse me?" Crockett opened her binder. "We'll get there. But first, I'd like to finish presenting the evidence you've repeatedly refused to acknowledge." Stones reached for his gavel but hesitated. The room felt different now. Crockett wasn't just presenting a case anymore. She was pulling back the curtain. Crockett let the silence hang for a beat. Then she stepped forward, calm but unrelenting. "Your Honor, before we proceed, I'd like to address procedural inconsistencies in your rulings on similar civil rights cases." Judge Stones narrowed his eyes. "You are out of order." "Actually, Your Honor," Crockett replied, voice steady, eyes locked onto his. "I don't believe I am." She reached into her binder and withdrew a thick, color-coded folder, tabbed and indexed. "This contains public records from 12 cases you've presided over in the past 5 years. All dismissed, all civil rights. 8 were overturned on appeal. 4 resulted in judicial conduct complaints." Murmurs rippled through the gallery. Stones gripped his gavel, but didn't strike it. Crockett continued. "In Henderson v. Texas Board of Elections, you sanctioned the plaintiff's attorneys and made comments later described as inappropriate by the appellate court. Do you recall that?" "You're treading dangerously close to contempt," Stones said, his voice low and shaky. "I'm treading directly in the path of truth," Crockett shot back. "And the truth is that civil rights plaintiffs have repeatedly been denied fair hearings in your courtroom. This case can't be evaluated impartially by someone with that track record." Stones sat back, clearly rattled. He looked around the courtroom, but no one came to his rescue. Crockett stepped even closer to the bench. "I move that this court recuse itself based on a demonstrable pattern of bias." "You're grandstanding," he said, voice cracking just slightly. "No, Your Honor, I'm protecting the Constitution, something every judge swears to do, including you." Stones blinked hard. "And I have 12 case files here," Crockett added, "that suggest you've broken that oath more than once." The courtroom held its breath. Crockett placed the folder gently on the clerk's desk. I'm prepared to submit these into the record and make a formal motion. Judge Stones didn't speak. His silence wasn't control. It was collapse. Crockett stood firm, gaze unwavering. The power dynamic had flipped. The judge was no longer the one in charge. She was. Crockett didn't flinch. She didn't blink. She simply reached into her briefcase and removed a heavy black folder, thick with printed tabs and color-coded dividers. The sound of the latch popping open felt like thunder in the dead quiet courtroom. For the first time all morning, Judge Stones looked uncertain. Your Honor, she began, rising slowly from her seat. Before we proceed, I believe this court must first address its own track record in cases of this nature. She opened the folder wide on the plaintiff's table, letting the audience see the mountain of paper. Every document was labeled, indexed, cross-referenced. I've compiled a record of your rulings in civil rights litigation over the last 5 years. There are 12 cases listed here. 12. She held up the first tabbed document like a lit torch. All 12 were dismissed. 7 were later reversed on appeal. 4 drew formal reprimands. 1 was referred to the Judicial Conduct and Disability Committee. Now the air changed. Crockett continued, calm and deliberate, her voice steady like a metronome. In Martinez v. Dallas County, you ruled the plaintiff lacked standing because, and I quote, he filed his complaint too emotionally. The Fifth Circuit reversed, calling your dismissal extraordinarily subjective and lacking in procedural rigor. Gasps whispered through the gallery. In Harris v. Board of Elections, you rejected statistical evidence of voter suppression because it failed to account for personal responsibility. That decision was overturned and remanded. The appellate court noted your use of a debunked 1990 study to justify your ruling. Stones adjusted in his chair. His hands tightened around the edges of his bench. In Mendez v. State of Texas, you sanctioned 2 civil rights attorneys for filing what you described as social media lawfare. Yet the Fifth Circuit vacated your sanctions and reprimanded your conduct as unprofessional and injurious to the public trust in the judiciary. She looked directly at him now, her tone sharpened without ever rising. Your Honor, I'm not speculating. These are not opinions. These are judicial records. Your words, your rulings, your reversals, your reprimands. Stones tried to respond, but Crockett raised a hand. With respect, I'm not finished. And respectfully, this court's credibility is what's now on trial. She turned a page. In Franklin v. Tarrant County, you ruled that the plaintiffs, all black voters, lacked credible evidence of interference, even after video footage showed locked polling locations. That case is currently under appeal. Meanwhile, you accused their attorneys of pursuing, and I quote, a media circus masquerading as litigation. The defense table was silent. Reporters' pens scratched furiously against their pads. The judge's law clerk looked up from her laptop with wide eyes. You've dismissed footage. You've denied affidavits. You've silenced attorneys mid-argument. And in nearly every instance, you've done so in civil rights cases. Disproportionately, consistently, and unapologetically. She leaned forward. That's not interpretation. That's a pattern. And that pattern doesn't align with the principles of judicial neutrality. It aligns with institutional bias and abuse of authority. The courtroom held its breath. Judge Stones didn't speak. His gavel sat unused. His face, once smug and composed, now showed the faint pallor of a man who suddenly felt the floor begin to crack beneath him. And Crockett hadn't even started playing her strongest cards yet. Crockett stepped away from the table, holding up another document from her folder like a prosecutor presenting exhibit. Let's start with Morrison v. Texas Secretary of State 2023, a case where voters in predominantly black neighborhoods were denied access to early voting locations. You dismissed it within 48 hours, stating in your written opinion that the plaintiffs were stirring up unrest with ambulance-chasing lawyers. She paused. That phrase, ambulance-chasing lawyers, was later cited by the appellate court as prejudicial language unbefitting a federal judge. They overturned your dismissal, and they filed a formal request to review your conduct. Stones stared at her, unmoving. The courtroom was silent except for the scribbling of journalists trying to keep up with the cascade of revelations. Crockett laid down that case file and pulled another. Next, Henderson v. Texas, Board of Elections, 2022. In this one, you went further. Not only did you dismiss the claim of racial gerrymandering, you sanctioned the attorneys, accusing them of abusing the court system for publicity. She tapped the document. Your sanctions were overturned. The appeals court said your actions had a chilling effect on legitimate civil rights litigation. That quote is from their written opinion, by the way. A murmur rippled through the audience. Stones shifted again, tugging at the collar of his robe. Crockett moved to the next file with a precision that was both brutal and brilliant. Jackson v. Harris County Elections 2021. A case involving the closure of voting precincts with majority Black and Latino populations. You dismissed the suit outright and told the plaintiff's attorney, and this is in the official transcript, stop wasting this court's time with conspiracy theories. She raised her eyebrows. That case? Reversed. Again. The Fifth Circuit found the plaintiffs had substantial evidence of disparate impact and criticized your tone as unnecessarily dismissive and lacking judicial decorum. Now Crockett turned toward the gallery. These are not isolated errors. These are not simple disagreements over law. These are patterns of conduct. Language that undermines confidence in the judiciary. Decisions that demonstrate a consistent hostility toward civil rights plaintiffs. She held up all 3 case files. You see, Your Honor, every time a civil rights case enters your courtroom, it leaves in tatters. Not because the law failed, but because you refused to hear it. Judge Stones looked down. For the first time that day, he appeared not angry, but exposed. But Crockett wasn't finished. She pulled out a thick stack, 12 more cases in total. Here are 9 additional dismissals, 3 with sanctions, 5 with appellate reversals. I won't read them all now, but each of them tells the same story. A judge more interested in control than justice, in silencing than listening. Crockett turned back to face him squarely. The law is not your weapon. It's your duty. And that duty doesn't disappear when the plaintiffs don't look like you, sound like you, or come from the same country clubs you once clerked in. Gasps again. A reporter's camera shutter clicked from the back of the room. Stones said nothing. The bench, once his throne, now felt more like a witness box, and every word Crockett spoke pushed him closer to being the one under examination. Crockett reached into her folder one last time, her fingertips grazing the final document like she was preparing to detonate a truth bomb. And now, she said calmly, we arrive at Davis v. Texas, Attorney General 2021. Judge Stones's face twitched. He knew that name. This was a coalition-led lawsuit brought by multiple civil rights organizations alleging voter intimidation and discriminatory ID requirements in rural districts. During proceedings, you dismissed their evidence in less than 10 minutes. Crockett stepped closer to the bench. Her voice dropped, but her tone sharpened like a scalpel. But that's not the shocking part. What shocked even the Fifth Circuit, what forced them to write an extraordinary opinion, was what you said to the plaintiff's attorneys that day. She held up the certified transcript. And I quote, "These people need to stop complaining about every little rule and learn to follow the law like everyone else." The phrase dropped like a bomb in the courtroom. These people. The silence that followed was thunderous. Your Honor, Crockett continued, her words slow and surgical. You didn't just dismiss the case. You dismissed the people bringing it. You reduced decades of lived experience, generations of disenfranchisement, and thousands of pages of evidence into 2 words that expose everything about your view of civil rights litigation." Stones's mouth opened, then shut. No words came. Crockett turned back to the courtroom and gestured to the pile of files on her table. "These are not isolated moments. They are a body of evidence, a pattern, a judicial record tainted by bias, contempt, and inappropriate conduct that undermines public trust in this institution." She looked directly into the judge's eyes. "This isn't a courtroom anymore. It's a crisis." The air in the room felt electric. "I move," Crockett said clearly, "that this court recuse itself from this case on the grounds of demonstrated bias and prejudice towards civil rights plaintiffs." Gasps. Reporters frantically took notes. Court staff froze. Even the defense attorneys sat rigid, unsure whether to speak or sit in stunned silence. "I further move," she continued, her voice unwavering, "that this court's conduct be reviewed by the Judicial Conduct and Disability Committee, based on the documented pattern of inappropriate dismissals, reversals, and ethics warnings I've just entered into the record." Stones, pale and silent, clutched his gavel but didn't raise it. "And finally," Crockett concluded, "I respectfully suggest, Your Honor, that continuing to preside over civil rights cases is no longer in the interest of justice, given the overwhelming evidence of bias I've just presented." There it was, the final blow. A legal takedown not shouted in anger, but delivered in complete control, with receipts, precedent, and purpose. The judge who had mocked her name, dismissed her evidence, and laughed at her strategy now sat frozen behind his bench. And the 33-year-old Congresswoman from Texas, armed with legal documents, sharp memory, and moral clarity, stood alone, unshaken, and undeniably victorious. She walked back to her table, placed the final document down, and waited. Judge Stones didn't say a word. He couldn't. He had just been dismantled, one case, one quote, one truth at a time. Before Judge Stones even stood from his chair, the courtroom was already on fire, digitally. Someone in the gallery had recorded the moment Jasmine Crockett dropped the Davis transcript. Within minutes, clips hit Twitter, TikTok, and Instagram. One video showed her saying, "That's not justice, that's abuse," laid over dramatic music and slow-motion zooms. Another froze on Stones's stunned expression as caption text read, "20 years of unchecked power, over." By the time Stones left the bench, the hashtag crushes Stones, was trending globally. Legal Twitter exploded. TikTok creators reenacted the courtroom moment. YouTube thumbnails showed Crockett standing tall, while Stones shrank behind his gavel. The most viral tweet came from a Harvard law student. She didn't just walk into that courtroom. She walked into history. Civil rights organizations issued immediate statements of support. The NAACA called it a masterclass in courtroom courage. The ACLG tweeted, "This is how you hold power accountable, on the record, with facts and with fire." Black Lawyers for Justice said it louder. Jasmine Crockett just did what most attorneys only dream of. Law professors weighed in next. Yale's Dr. Benjamin Holt called the confrontation historic, while Columbia's Felicia Mendez said she was reworking her next semester's trial advocacy syllabus to include the case. "Every student will study what just happened," she wrote. "Every judge should too." Even some members of the typically conservative legal community couldn't deny the moment. While the Federalist Society declined comment, several prominent legal scholars associated with it reposted Crockett's speech without criticism, an omission louder than words. Cable news erupted. MSNBC went wall-to-wall coverage. CNN dubbed the takedown the most decisive courtroom reversal of the year. And even Fox News, usually skeptical of congressional Democrats, aired an uncut clip of the confrontation, with anchors visibly shaken. One conservative guest even admitted, "Whatever your politics, that was textbook legal domination." And? Crockett? She said nothing. Just one tweet. A video of her closing her briefcase with the caption, "Preparation is power." No hashtags, No grandstanding, just calm certainty. Because she knew. The nation saw what she did, and the tremors had just begun. The day after the hearing, Judge Andrew Haight Stones was nowhere to be found. Instead, his courtroom clerk entered with a typed statement. Due to unexpected health concerns, it read, Judge Stones will take an indefinite medical leave of absence. He never returned to the bench. Legal experts knew what health concerns meant. It was a quiet exit strategy. But Crockett's motion for recusal had already set off a chain reaction that couldn't be silenced with a resignation. By noon, the Department of Justice announced it would review past rulings in all 12 cases Crockett had cited. The Judicial Conduct and Disability Committee confirmed they had reopened their dormant investigation into Stone's record. It was no longer just courtroom drama. It was institutional reckoning. Cable news kept rolling. CNN aired a primetime special titled Power on Trial. The New York Times ran a front-page profile headlined, How One Congresswoman Challenged the Federal Bench. Even Fox News ran a headline that stopped viewers cold. Judge faces ethicsy after viral courtroom moment. Penshow Crockett, meanwhile, stayed focused. She returned to Congress the next day and co-sponsored new legislation on judicial transparency and accountability. In interviews, she made it clear, this isn't about vengeance. It's about making sure justice isn't just a word carved into marble. Law schools across the country began requesting permission to use the courtroom footage in legal ethics courses. Professors described it as a once-in-a-generation moment that revealed the soft underbelly of unchecked power. Legal blogs named it the Crockett Doctrine, a blueprint for documenting, confronting, and dismantling bias in real time. Support came pouring in. Civil rights attorneys shared similar stories of judicial hostility. Activists circulated petitions for further investigations, and ordinary Americans, many of whom had never followed courtroom news before, started talking about judicial bias at dinner tables and on timelines. In 24 hours, Crockett didn't just go viral, she sparked a national conversation. And Judge Andrew H. Stones? He became the symbol of what happens when arrogance meets preparation, when unchecked power collides with unshakable truth. Because Crockett hadn't just challenged a judge. She had cracked open the walls of the federal judiciary and let the sunlight in. This wasn't just a courtroom show. It was a national awakening. Jasmine Crockett didn't just confront a judge. She confronted a system. And in doing so, she proved that even the highest bench in the land isn't above being held accountable. In a courtroom where arrogance had gone unchecked for 2 decades, she walked in calm and calculated, armed not with rhetoric but receipts. She didn't argue. She exposed, with every document laid down, she tore the curtain off judicial immunity and let the American people see what was hiding behind it. Bias, patterns, and silence. But what made this moment historic wasn't just the takedown. It was the blueprint it left behind. Law schools began teaching her strategy. Civil rights organizations began documenting judicial bias like never before. And soon, what was once whispered in legal circles became codified. The Crockett Protocol. A systematic, evidentiary approach to confronting judges who had operated for too long without scrutiny. Judge Stones retired under the cover of medical leave, but everyone knew what really happened. His power collapsed, not with a scandal or a bribe, but under the weight of facts. His replacement was everything he wasn't. Empathetic, community-rooted, and battle-tested on behalf of the people. Meanwhile, Crockett emerged not just as a courtroom force but as a political one. Her name circulated in conversations about judicial reform, oversight legislation, and even future leadership. And across the country, lawyers, students, and citizens began to ask a once taboo question. Should judges, especially those with lifetime appointments, face public, transparent performance reviews? The answer could redefine justice in America. And the movement has already begun. Because Crockett reminded us, justice isn't a costume. It's not in the robe. It's in responsibility, It's in truth, and it lives wherever someone has the courage to stand up and say, "This isn't right." So we ask you now, should the people have the power to grade their judges? Tell us what you think in the comments. And hit subscribe, because next time, we're uncovering a Supreme Court scandal so big, it could shake the foundation of American law. Justice is watching. So are we.